Good morning, everyone. Virgo here. It is August 14th, 2019, and welcome to Snoop4Truth Wednesday. Today we're going to be going over the Moors and what the courts think of the Moors. We're going to be going over several pieces of case law that Snoop has pulled for us in order for us to take a really good, serious look at what the courts really feel about what's presented by the Moorish community. And by the Moorish community, I'm speaking of those online Moors that we talk about and that largely like to use documentation similar to what the Sovsits use. Before we do that, I have a couple of things I'd like to show you. One of those things being something that our favorite agent Sock sent us. You might remember that last week we had Sock Puppet's ID from the Moorish national government that went up on my channel so that you guys could see Sock with his fez on. Well, last night I received greetings from Sock. Scenic Mount Rushmore, M-O-O-R, a really real place you can totally visit. Take a look at those faces, you guys. Anybody on there look familiar to you? Okay, on with the party here. Okay, so time and time again I've had you guys ask me, what happens to the documentation that gets sent off? So, for example, if Sharon does a lien on someone, or someone in the Moorish community follows Sharon's advice or class and attempts to try to do a lien, where is it being sent? Is it being sent at all? Well, it appears to be that several in that community are starting to receive things they weren't anticipating coming back from areas that they're sending these liens to. Here's one that you can take a look at for yourself. The government of the District of Columbia, Office of Tax and Revenue Recorder of Deeds, sent back a notice on this particular party's lien that says this is not a recordable document in DC Recorder of Deeds office. All right, if you keep looking, you will see that there is a second sheet of paper here that talks about the notice that's regarding the Recorder of Deeds discretion, meaning that based on the case law that is noted here, Dancy versus Clark and Mayers versus Ridley, that the recorder actually has the discretion to take a look at what's going on with the documentation that they're receiving, and if it isn't something that's proper in terms of what they normally would record there. For example, it states if the lien holder and the debtor are the same person, if the debtor did not grant the lien. Yes, see, right there, you guys can see how screwed up this whole scenario is with the Moors and with the Sovsits that do this kind of thing. The debtor actually has to agree to the lien. That means two flesh and blood people. It doesn't count if it's your quote-unquote straw man. If the debtor did not grant the lien and the secured property is not really the owner, then you can't file this document legally. If the secured property is actually not owned by the debtor, you can't file one either. But in the case of the Moors, these are just totally fraudulent. So here we go with one that has to do, again, with commercial land. And let me just fill you guys in on what it is that these people are actually filing these liens with regards to. So, acting commissioner of the Social Security Administration, Nancy Ann Berryhill, is who this lien was filed against, this fraudulent lien. And it was filed by one of the Moorish, obviously, and he's going by William L. Anderson L. Okay, and he's out of Alabama. And the funniest part about this entire thing is the reasoning behind the filing of it. So if we go down here, you see that this is, I call it a gazillion, but it's really a quadrillion amount back of gold-backed lawful tender, which is on every single one of these ridiculous liens. But the actual reason behind the filing of this is stated right here. The only flag that will fly at North America, Morocco, is the Moorish American flag, red with 5-pointed green star, and all U.S. banners, they're speaking of the flag now, of amity and commerce are outlawed and are commanded to be removed immediately. So they're now filing liens against individuals. Just whoever they randomly choose, apparently, because obviously the acting commissioner of the Social Security Administration is not necessarily who's responsible for the flag that's flying on the property. It isn't even necessarily true that whatever building that they're in is actually owned by that specific agency. You just don't know. But regardless, it doesn't matter. This person decided that they wanted to pick on Nancy, so Nancy's the one who's got the fake lien against her. All because an American flag, what they call a banner, is flying above the Social Security Administration in whatever location this is. Ridiculous. But for those of you that wanted to know, and we're getting ready to go over the court cases also, but for those of you that wanted to know, this is the type of documentation the first time that will come back if you file something fraudulent or something frivolous with the Washington, D.C. Recorder of Deeds office. However, if they continue to get them, you best believe that there are some criminal penalties that can be charged. You can't be filing fraudulent paperwork with the Recorder of Deeds over and over again. And with the Treasury, for those that choose to file theirs there, okay, things like A for V, stuff like that, they impose a $5,000 fine for those. Generally, you're not even given the opportunity once. So, just so that you guys know, and have the information that you've been asking about, this is an example of what's coming back. None of the liens that have been filed by the Moors are legitimate. None of the liens are being recognized by anybody of authority within the United States government. And if they're not being recognized by any authority, by any federal authority or state authority, they're not going anywhere. And the whole point of this, to be quite frank with you, the whole point of the liens and all of that stuff that Sharon pushes, it has absolutely nothing to do with actually doing what she claims. You're not going to be able to get a property. You're not going to be able to, get anybody out of their property. All of that is just to incite anger and to make you feel empowered to get you into the fold of the actual movement. Let's take a look at some of the cases that Snoop pulled, showing us how the court feels about the Moors and their movement. Okay, so you guys, I'm going to be going over a few of these cases with you, but I'm not going to be reading all of them in their entirety. This one, I'm going to read. This is John Jones Bay versus the state of Indiana. Okay, so here we go. Okay, this, of course, was the United States Court of Appeals 7th Circuit. This was submitted October 27th, 2016, and decided on February 3rd, 2017. Appeal from the United States District Court for the Southern District of Indiana, Indianapolis Division. John Jones Bay, who pro se, so he was on his own when he was in court. And let's see. John Jones Bay, who describes himself as an Aboriginal Indigenous Moorish American, filed in the district court what he labeled a writ of mandamus, seeking to enjoin state and county officials from taxing real estate that he owns in Marion County, Indiana. He also asked that the defendant officials be ordered to refund the taxes that he paid and to compensate him for their alleged wrongs. He asked the district court to award him $11.5 billion. The court refused and granted the defendant's motion to dismiss precipitating this appeal. $11.5 billion. These cases just crack me up, you guys. I'm sorry. I'll probably do a lot of laughing during these because these are important, not only because they're on the record, but also because a lot of these judges get so irritated with these folks that they actually go into great detail with regards to things like the peace and friendship treaty and how it doesn't mean anything like they say that it means. And I'm going to be taking you through some footnotes on another one of these cases that I think you guys are going to find really, really entertaining. Bay says that he's a Sovsit and therefore can't lawfully be taxed by Indiana or its subdivisions in the absence of a contract between them and him. And then it gives you some case law that you can take a look at. We do so in this case as well and thus affirm the district court. Okay, so this is, let's see, we have repeatedly rejected such claims. We do so in this case as well and thus affirm the district court. Excuse me, I had forgotten that line in between. But we want to take this opportunity to examine the rights asserted in this as in the other cases we've cited by persons describing themselves as Sovsits by virtue of their alleged Moorish origin. Most of them are African Americans who belong to the Moorish Science Temple of America and claim to be descendants of the Moors of Northern Africa, though they are not. Moors are of mixed Berber and Arab descent rather than being African American in the usual sense of being descended from black Africans. The original purpose of MSTA, founded in the 1920s by Noble Drew Ali, whose followers call themselves the Moors, in place of more conventional designations such as black or African American or colored, was to claim government, quote, recognition and respect as full citizens rather than the second-class descendants of slaves, end quote. Let's see. This goes into Southern Poverty Law Center and what they have to say about the Moors. MSTA focuses on uplifting its followers and encouraging them to vote in U.S. elections so that they can escape political slavery. Spencer Drew on his book Moors Know the Law. And also, just so that you guys are aware, and I know I'm sporadically going through this, but just so that you guys are aware, there is actually a great deal of information with regards to the difference of the Moors. Now, for those of you that don't actually aren't a Patreon on my Patreon account, I just got through doing a history of the Moors to give you an idea of the difference between the actual Moors and those that are calling themselves Moors. And so if you want to take a look at my Patreon account, you can go to www.patreon.com/VirgoTriad1. For as little as $1, you can become a Patreon, and you can see that hour and a half long documentary that was done. It's very informative. It takes you way back into history when the Moors actually ruled over Europe, and it gives you all kinds of information with regards to the Prophet Noble Drew Ali and who he really was, what he really did for a living prior to starting the religious Moorish Science Temple of America, who are actually totally different than the online Moors. So I wanted to make sure that I said that, just because not all of the Moors that are out there believe in this Sobsit kind of junk. They don't file false liens against people. They don't file frivolous lawsuits against people, and they're law-abiding citizens. There are a ton, however, online who do this kind of garbage. So the MSTA Home Office located in Washington, D.C. has issued a statement clarifying that the organization is neither a Sobsit movement nor a tax protester movement, and that it was not founded for its members to become anarchists or conspiracy theorists. Moorish Science Temple of America statement on radical and subversive fringe groups as of July 15th, 2011, on the actual Moorish Science Temple 1913.org website. A MSTA temple in Georgia denounces Sobsit propaganda as completely asinine and asks that Moors not adopt the ideals of this European groups who, at their core, hate Moors' very existence. Frequently asked questions. Question 1, Moorish Science Temple of America, Georgia, moorishsciencetemple.org facts. Okay, so what the court is talking about here is actually kind of important. And the reason why it's important is because time and time again on my channel, I've gone over the redemption theory, which has to do with these crazy liens and the UCC and all of this other stuff. What the Moorish consulate is doing right now is picking up on the Sobsit movement, which believes in the redemption theory. The redemption theory was actually brought about by a man named Roger Elvick, who was a white supremacist. This was started in very, very racist grassroots. Had absolutely nothing to do with the Moors whatsoever. It's just been adopted by them. All right, but clearly Sov citizens' ideas appeal to many self-described Moors who combine those ideas with Ali's teaching in an effort to reclaim and rewrite Black history. For example, the Moors' Order of the Round Table uses 18th century treaties with Morocco to distinguish free Moors from Africans who could be enslaved, and teaches that courts have no jurisdiction over Moors. We know that's not true. Other groups claim that their Moorish nationality gives them the status of the United States as indigenous people, although the logic behind this claim is deeply obscure. Okay, you can see Renita Bay teaches that Europeans are latecomers and Moors never granted them citizenship. Washita Nation comes under investigation. Intelligence report from the Southern Poverty Law Center, written June 15th, 1999, with this specific link. I will go ahead and put in the description so that you can look it up for yourself. She teaches her followers that they are Moors from Mu, who, or Ma, I don't know how that's pronounced actually, whatever, who traveled to North America before Africans did, when the world had only one continent. Many sovereign citizen organizations teach that whenever a Moor's name is spelled in capital letters in a government document, the name identifies not the individual, but instead his corporate shell entity. And we've all heard of the straw man theory before. So here we go into the whole Sobsit movement stuff that these Moors picked up on. Although the Moorish Science Temple does not buy the Sobsit line, many of its members do. Many of them argue without any basis in fact that as a result of the 18th century treaties, the United States has no jurisdiction over its Moorish inhabitants, who are therefore under no obligation to pay taxes. That is Bay's position, but he does not explain how it entitles him to $11.5 billion refund from the state of Indiana Indiana, thank you, and or its subdivisions. You guys know that I haven't had enough coffee this morning. Nor is there any basis for his contention that he's not required to pay any taxes because being a Moor makes him a Sovsit. He may be a Moor, but we emphasize in the hope of staving off future such frivolous litigation, he is not a Sovsit. He is a U.S. citizen and therefore, unlike foreign diplomats, has no immunity from U.S. law. Indeed, his suit is frivolous and was therefore properly dismissed. He was lucky to be spared sanctions for filing such a suit. All right, so this one will be linked in the description, as will the others that I'm going over here. I'm not going to give too much away with regards to this case from 2011. As you can see, these are all Moors that are involved in this case. This is an amazing case to read. If you're into doing research on how crazy the Moorish movement is, this case is for you. I'm going to link it in the description with a big star next to it, because I think everybody should actually take a look at this. But what I want to do is I want to go, there's a ton of information in it. It literally debunks everything, but I'm not going to read the whole case because it is extremely long. What I am going to do is take you down here just to the footnotes because they are interesting enough. So let's see. Here we go. Number 1, the underlying term Moors seemingly reflects the adherents' interest in highlighting their actual or alleged ancestry in ancient Moors, i.e., the 17th century Muslims of the Islamic Iberian Peninsula and North Africa who were Berber and Arab descent. Number 2, the concept of Sovsits does occasionally relate to the phenomenon of world passports. World passports issued by the so-called World Service Authority, WSA, are not recognized in the United States and in the majority of the world nations as substitutes to official documents such as national passports or driver's licenses. And then it gives you the case to take a look at. Number 3, this estate concept is legally deficient on its face, as one court explained. Such estates of litigants cannot qualify as actual litigants since these estates offer no order by a probate court acknowledging the existence of these estates, and indeed it would be surprising had such order been entered because it is well established that the body of a descendant cannot be an estate or even a part of an estate. I mean, talk about just wiping out literally everything that they claim. Number 4, such claims of diplomatic immunity are without merit, as it was already observed. Plaintiffs are in conflating their expatriation and diplomatic immunity arguments, since plaintiff seems to focus on an irrelevant fact that anyone may renounce his or her United States citizenship, but this fact in no way establishes that plaintiffs actually expatriated in accordance with the applicable legal requirements. So, of course, if you're going to expatriate yourself, you need to do it properly, because otherwise it doesn't mean a damn thing. But in addition to that, regardless of whether you expatriate yourself or not, you're still under United States jurisdiction if you break the law. You have no diplomatic immunity. This online form and the one from the book have been widely used in federal and state courts by many self-proclaimed Sovsits. See the form used by an individual who referred to himself as Malik Naim Bey to initiate an action on a Michigan state court application to the same court by an individual who referred to himself as Yusuf Rahim Bey. Are these names sounding a bit familiar, folks? Addressed to Connecticut State Court by an individual who referred to himself as Anid A.L. Addressed to the United States Supreme Court by an individual who referred to himself as Andre Asaya Gabriel Bey. Addressed to the United States District Court for the District of Columbia by an individual who referred to herself as Mary K. Bowles Bey. Number 6, for instance, the writ of error, boilerplate, being garnished with senseless placard excerpts from the United States Constitution, instructs to write to the court the following: I am in receipt of your instrument dated blah, 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 signed by Deputy Clerk blah, 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 regarding your responses to the affidavit of financial statement for the record, on the record, and let the record show I am a Moorish National Aboriginal Indigenous natural person and not a nom de guerre, straw man, or any other artificial corporate construct as written in all capital letters by the unclean hands of others. I am a sovereign to this land, and as such, this administrative court does not have lawful jurisdiction to hear, present, or pass judgment in any manner concerning my affairs under a quasi-criminal, non-sanctioned tribunal of foreign private law process in response to your misrepresented assumption that my affidavit was a motion. Let the record show it was an exercise of right in forma pauperis. Clearly, your demand for a financial statement is used as an instrument to deny due process of law and my right to free access to the courts. I introduced an affidavit of fact marked as evidence. Someone in the courts tampered with that evidence and misrepresented it as a motion. A motion is discretionary and an assumption that permission must be requested to exercise a constitutionally secured right. An exercise of a right is not a request, and your office knows this to be, what is this? Stare decisis. Yeah, And the law of the land, tampering with evidence, is a federal violation and a clear corruption of the fiduciary duties of all courts officers. Furthermore, there is no law prescribed in the United States Constitution stating or requiring a financial statement, financial fee, feudal law, or a motion to exercise a constitutional secured right. Your demand is in violation of Amendment Number 9 of the United States of Constitution and a violation of my secured right to due process. I respectfully, with good faith and with honor, demand free access to the court by right, with said access unhindered by rightful due process. I submit this affidavit of financial statement and evidence and demand that it be processed as it was originally intended and without tampering by any unauthorized persons. For instance, the writ of error, boilerplate, being garnished with senseless plucked excerpts from the United States Constitution, instructs to write to the court the following. And this is what I just read to you. Okay, here we go. Number 7. Although Section 1915A refers to a statement of all assets such prisoners possesses, this section has been applied by courts in their review of application of non-prisoners as well. And we didn't go over that section, but that's number 7. Number 8 is this heading is accompanied by following statement. Now, I'm not actually going to read this entire statement to you, but I do want to take you up and show you one other section that I think you guys will find very, very informative. Okay, so here's the part of this case that I wanted to read to you guys. It starts right here. This is particularly obvious in the treaty with Morocco, which was a short accord consisting of a mere 25 articles, with only 3 articles focusing not on acts of war, vessels, merchant activities, etc., but on the acts against generic civilian human beings. See 1836 UST Lexus 10 Arts 6, 20, and 21. None of these 3 articles could be read as applying to habeas or civil rights claims raised by the Marrakesh litigants against state police or prosecutorial officers or judges as to the claims based on the events of their arrests, incarceration, bailing, prosecution, convictions, etc. Indeed, Article 6 of the treaty was fashioned to prevent undue enslaving of American citizens and also to prevent theft of American citizens' goods in the Mediterraneans by pirating Moors who were either of Moroccan or non-Moroccan domicile and who were taking undue advantage of the passageways trade. All right. So all of the crap that you're being told online by the Moorish consulate is total BS. And this is part of what proves that. This is case law that's been taken directly from the treaty. And it shows what the treaty was for. This has absolutely nothing to do with the Moors being of some indigenous people or of them taking the place of the American Indians, being a part of the American Indians, or having anything to do with the land we call America. Nothing to do with it at all. It's a lie. And that's partially the reason why I'm going over these with you guys, but also because they're just plain interesting to take a look at. I want for you guys to be able to actually look at some true, real case law that shows you how the courts respond when you start filing things like Sharon Tracy Gale Bay has filed, like many of the Moors that came before her have filed, and many, unfortunately, will continue to file after Sharon has paid her price for some of the things that she's now doing. It's a sad situation because these Moors are being misled so badly, and they're being brainwashed so much that if you were to put all 6 of the cases that I've got for you guys to look at in front of them and put them in layman's terms, it wouldn't matter. They are that brainwashed. But there has never, ever been a case that I have been able to locate, or Snoop that I'm aware of has been able to locate, or anyone else who has researched the Moors or the history of the Moors as much as we both have, where they've won based on the arguments that they use. Some other interesting things about these cases that I'm going to be listing in the description of this video for you are they go over the fact that the Moorish National Republic, Moorish Divine and National Movement of the World, Aboriginal and Indigenous Natural People of Northwest, a Maxim North America Affidavit of Financial Statement, documents, none of this stuff is recognized. None of it. The Moorish National Republic government, not recognized. None of this is recognized by the federal government of the United States. It's not recognized by any of the states within the United States. It's not recognized by any tribal community within the United States of America. It is not recognized at all. This is completely and totally a fluff dream that has been dreamt up across the internet. It is something that is embarrassing to the Moorish American, the Moorish Science Temple of America. It is something that is 100% a scam. And these particular cases will help you to, especially this one. I'm going to put a big star by this. This one gives you a great deal of information and where to locate all of the information on where these people, can find, where you can find that what these people are saying is complete BS. It's all legally there in law. It's all there. All right, one more case. Okay, this is from the Court of Appeals 6th Circuit from 2017. This is the United States of America versus Aries A. Coleman. And this case is actually about a felon who pointed a gun at a repo man in 2015. And I'm going to kind of go over the background. I'll probably read the majority of this to you guys. It's an interesting one. On November 17th, 2015, defendant pointed a gun at Gary Valentine, a recovery agent with a vehicle repossession company, and threatened to shoot him. As a result, he was indicted on charges of being a felon in possession of a firearm and ammunition in violation of 18 U.S.C. 922G1. At his arraignment, defendant acknowledged his presence in federal court, but challenged the court's jurisdiction over him. Specifically, he contended that the government was trying to charge him with a commercial crime and that the United States could not be the victim of a commercial crime. Defendant also asked the magistrate judge if he was forcing the defendant to contract. So this whole, you're going to force me to joinder with you, and referred to him as a flesh and blood living being. He claimed that his detention on U.S. soil was unconstitutional. Several weeks later, defendant's appointed counsel, Assistant Federal Public Defender Charles Fleming, moved to withdraw as counsel after the defendant became combative and confrontational during a meeting. At the hearing on the motion, defendant told the court that he was present on special appearance as a third-party intervener and claimed that he was a beneficiary and executor to the legal estate of the defendant, stated that he had surrendered his birth certificate to the court for set-off settlement. He contended that he was not a corporation, an estate, or a legal fiction, but rather a living man, living private on the land, and he authorized the court to settle and close the account case constructive trust. Defendant also claimed that the court lacked jurisdiction and referenced his copyright. The district court granted Fleming's motion and ordered that defendant receive other counsel. Several days before trial, defendant filed a pro se notice reiterating his challenge to the district court's jurisdiction. In it, he explained that he is a living man, not a corporate fiction, who never signed any contract with the public defender's office. He also indicated that he had appointed respondent James S. Gwynn as trustee to settle and close the case. Defendant signed the notice as his own authorized representative and listed an address in Warren, Ohio Republic with a zip code in brackets. Defendant included an affidavit of ownership, declaration of nationality, certificates of titles, birth certificates, stating that he was a Moorish American national and claiming that using any of his titles mentioned in the declaration required payment of, look at that amount again, folks. Look familiar? Per hour even, upon occurrence. He further included several documents from the state of Ohio, his original birth certificate, and a common law copyright notice for his name. Finally, he attached a proposed order of dismissal with prejudice pursuant to Rule 12B12 of the Federal Rules of Civil Procedure, alleging the lack of subject matter jurisdiction and the lack of personam jurisdiction. So there you go, Sharon. There's your personam jurisdiction, honey. Okay, the trial testimony. Valentine was the first to testify. He stated that when he attempted to repossess the defendant's truck on November 17th of 2015, pursuant to the repossession order, defendant pointed a handgun approximately 6 or 7 inches from Valentine's face and threatened to kill him. The defendant's wife intervened and Valentine was able to contact the police. There we go. I blew this up for you guys just a little bit. Defendant gave his side of the story. According to defendant, after his wife told him that Valentine was trying to repossess the truck, the defendant went home and tried to start the vehicle. It wouldn't start, and the defendant asked Valentine what he had done to it. Valentine allegedly said he doesn't know nothing and refused to provide any papers. Defendant's wife arrived. After that, defendant noticed that Valentine had a gun and was shaking it. Defendant claimed that he smacked the gun from Valentine's hand, grabbed it, and put it in his house. Pursuant to a search warrant, police found a loaded small black revolver with a white handle on the kitchen counter, a firing position where a slight pull of the trigger that, at that point, would have caused a bullet to go through the revolver. It was later determined that the firearm and ammunition were manufactured outside of the state. The jury convicted defendant of being a felon in possession of a firearm. After trial, defendant filed a pro se motion to dismiss his second attorney, Fernando Mack. Mack's tenure as counsel lasted through the trial. In a supporting affidavit, defendant claimed a conflict of interest because Mack demanded a fee in return for a winning verdict, which defendant was unable to pay. After he further accused Mack of failing to communicate with him and claimed that Mack was unprepared for trial. Defendant referenced the Strickland standard in connection with his complaints against Mack. At the hearing on defendant's motion, Mack described defendant as a pretty paranoid about his representation because he felt like Mack was working for the government, and this court had sent Mack to sabotage the case. Mack stated that throughout his communications with defendant were difficult because defendant insisted that they would not discuss the facts of the case. Mack also stated that defendant was under the impression that if a particular document was read in open court by Mack, the court would release him. This is the kind of garbage that these people are getting from the likes of people like Sharon Tracy Gale Bay. Defendant testified that Mack did not pursue a suppression motion as requested, citing the 4th, 5th, and 6th Amendments. Defendant also claimed that he did not want to testify at trial, but Mack insisted he could not argue facts for defendant unless defendant got on the stand and argued facts. Defendant explained, however, that both he and his wife, did not want to argue for a corporation, and that is why he tried to be respectful and said that he wasn't the defendant but a man. Defendant described the impact his incarceration had on his family and his health. Defendant insisted that the debt has been taken care of. The court relieved attorney Mack and appointed a new attorney, defendant's third attorney, by the way, to represent him at sentencing. Here we go into sentencing. During allocution, defendant told the court that this has been the worst 7 months of my life, and that he only wanted to be there for my family economically, physically, spiritually, and emotionally. He described his difficult childhood, which included physical abuse, and stated that his family was everything to him. He also noted that he was the first person in his family to receive a bachelor's degree, and that he intended to obtain a master's degree. In addition, he noted that he had completed a play which FSP Records was backing. He said that his past inspired him to be a loving husband, a great father, a great leader, a coach, a youth and adult mentor. Defendant detailed the hardships his incarceration had on his family. His wife lost her mother, and their son attempted suicide. He told the court that he never meant to dishonor anyone in this courtroom, and that he always wanted to provide for my family. He relayed the fact that he had saved another inmate's life while incarcerated, which showed his character. He urged the court to send him home so that he could be there for his wife and children. Lastly, defendant stated that he had a guaranteed job on anger management in LA with Charlie Sheen. Defendant's wife, Renee, also addressed the court. She described defendant as having an overall calm demeanor. She described him as very thoughtful, helpful, respectful, caring, and open-hearted. Renee confirmed defendant's accounts that he mentored adults in the community, was a coach, and that he had a, quote, play that he was ready to produce at FSP Records. The district court calculated an advisory guideline sentence of 37 to 46 months based on a base offense level of 20 and the criminal history category of 2. After considering the parties' statements and arguments and the applicable advisory guideline factors, the district court imposed a 36-month prison term. Now, for the first time on appeal, defendant argues that the court erred by failing to order a competency evaluation. I'm going to leave this here because we're already at almost 47 minutes, but I will link every single one of these cases to the description. I encourage you to please make sure that you read at least the first one with the star next to it. They're pretty amazing. I want to thank Snoop4Truth for all of this great information. It shines a new type of spotlight into the way the courts feel about the Moorish movement and how the online Moors are just going to continue to get their own grouping of individuals tossed in the clink because they just don't seem to understand that the courts, they already know what you're up to, and they know that it's fraudulent. All right, everybody, I hope you have a wonderful day. Once again, thanks so much, Snoop, and we'll talk to you soon. Bye-bye.